Thank you, Mr Speaker. Yesterday I rose and spoke on the Canterbury Earthquake Bill, and we've heard further this afternoon, sir, of the devastation and the destruction that was born on Canterbury. Sir, the earthquake in Canterbury is probably the number one natural disaster that has happened in my lifetime. There may not be another disaster, sir, that is dramatic and has such far-reaching consequences as happened in Canterbury during my lifetime. Sir, on a similar note, later this afternoon the House will be debating the first reading of the Marine and Coastal Area Tukutai Moana Bill. And sir, I'd like to suggest that this is the single most important bill that has been debated in my short time in Parliament, and I suspect will be the most important bill that is debated in my entire parliamentary career. Mr Speaker, this bill has major constitutional significance. Major constitutional significance. It has the potential to alienate.
Honourable Trevor Mallard.
Mr Speaker, I note my colleague Darren Hughes is much more up to date with standing orders, is not here, but it certainly used to be against the standing orders and Speaker's rulings of this House to anticipate a debate. I'm not sure if we've abandoned that rule now, but when something in the past, when something's been on the order paper for debate, it hasn't been able to, the substance of it hasn't been able to be debated in the general debate.
The member is certainly right that in the past that has been correct. I'm not aware of the standing orders having been changed to change that, and so maybe since that bill is on the order paper, the member should maybe it's okay to refer to it, but to focus the entire debate on it is in some ways to anticipate the bill. I don't want to be too pedantic about it, but a point of order has been raised, so I just alert the member, and I'm sure to talk about it in very, very general terms is probably okay. John Pascal.
Thank you, Mr Speaker. Well, what I will do, Mr Speaker, is I'll actually talk about the Seabed Act 2004, an existing act in Parliament, and the circumstances that gave rise to the passing of that act. But let me address the issue of the emissions trading scheme. Mr Speaker, I did campaign vigorously against the emissions trading scheme, and in its simplest expression, one can look on the emissions trading scheme as a $500 million surcharge on all New Zealanders per annum on their electricity and petrol. A $500 million per annum surcharge on electricity and petrol, creating a huge pool of money which essentially, Mr Speaker, goes to subsidise forests. So what the government did with the emissions trading scheme was to decide to tax New Zealanders $500 million a year and give it away. And Mr Speaker, what my colleague David Garrett will be speaking on later this afternoon is something far, far more important than that, far more important than the emissions trading scheme, and something of far greater constitutional significance. Sir, the 2004 Seabed Act came out of the case of the Crown, the Attorney General versus Ngāti Apa. In essence, what happened there, sir, there were some mussel farmers in the Marlborough Sounds that sought a ruling on customary title in that case, sir. They sought a customary title, and the court in ruling, the appeal court ruling in 2003, overrode the decision in 1963, the so-called 90 Mile Beach case, Mr Speaker. And what did the justices say, sir?
Point of order, the Honourable Trevor Mallard.
I think, sort of, notwithstanding your ruling and followed by a minor diversion, I think we've just gone back to a speech which is on, now completely on, the matter which is further down on the order paper.
I'll hear John Pascal.
Mr Speaker, I'm speaking about the 2004 Seabed Bill and the circumstances that gave rise to the passing of the Seabed Bill, and at the time, the Foreshore and Seabed Bill. And at the time I was speaking, Mr Speaker, I was talking about the decision by the Justices of the Appeal Court of New Zealand in the Attorney General versus Ngāti Atua.
I hear the honourable member. I must say on this issue, the standing order around the general debate is very broad. It doesn't preclude any topic really being excluded from the general debate. Members traditionally talk about almost anything in the general debate, and I don't want to start constraining what members can talk about too much. If the member can find but if the member can find for me specifically the standing order, which I'm looking for myself to guide myself better. It's 109. A member may not anticipate discussion of any general business or order of the day, and determining whether a discussion is out of order, the Speaker has regard to the probability of the matter anticipated being brought before the House within a reasonable time. And I guess with respect to the details on the foreshore and seabed bill on the order paper, that will be coming before the House very shortly. So the member will just need to be a little careful about how he shouldn't refer to detail in that bill. And so long as he doesn't do that, I don't want to constrain the member too much during the general debate. John Descaun.
Thank you, Mr. Speaker. And I won't speak about the detail of that bill, but what I will speak about, Mr. Speaker, is speak about the circumstances that gave rise to the passing of the 2004 Seabed and Foreshore Act. And I'd like to take this opportunity to say to the government, to say to the National Party, that the 2004 passing was of major constitutional significance. As Tariana Tiria reminded me a short time ago, the ACT Party opposed the passing of the 2004 bill, and the reason we opposed the passing of the 2004 bill, we believed in property rights. We believed that Maori should have the right to bring a customary claim, Mr. Speaker, as the judges in the appeal court said in 2003. But what those judges said, Mr. Speaker, is they said that to bring a case for customary rights, you had to show continuous and exclusive occupation of land from 1840. And the judges said, while Maori should have that right, the number of Maori who would be able to meet that test would be small, if any. Small, if any. And what did the government do? The government at the time, the Labour Party, went out and confiscated the rights of Maori. They passed the law that denied them the chance, Mr. Speaker, to seek customary title. However, what has happened, I won't discuss what is proposed. I will leave that to my colleague, Mr. Garrett, in less than an hour. But we have to be very careful about the consequences of passing that bill and unwinding that bill. Because I say again, Mr. Speaker, what gave rise to that, Mr. Speaker, was a ruling by the appeal court judges that one had to show exclusive and continuous occupation of that land from 1840. And the knee-jerk reaction of the Labour Party was to pass the Seabed and Foreshore Act.
Louise Upston.